from Patton Sullivan Brodell. On the calendar front, before jumping into this morning's program, I'd like to give a plug for next Friday. We have the 1031 update presentation by James Calais. That program was scheduled in March before the shelter in place. And so we've got that set for next Friday. On that topic, today we have when force majeure isn't enough, lease renegotiation due to commercial frustration in the era of COVID-19. We have Robert Jacobs as the presenter. Mr. Jacobs mediates challenging real estate business and construction law cases. He's also very active in the bar. He is, as you probably know, the chair of the ADR section for Contra Costa. He's also the co-chair of the ADR section. He's an author, he's an update author for CEB on the Guide to Real Property and Remedies. And next year, I believe he's rewriting the chapter on ADR for CEB. He has, just as we go along, you can ask questions. He has a very detailed presentation that he's going to work hard on keeping to an hour, but I think what we'll do is monitor the questions that come through the chat feature and try to cover those at the end of the presentation.
Thank you, Randy, and welcome. Just a clarification on the announcements or the publicity on this program. In the body of it, it said it was an hour, but the program's scheduled to run to 10:30. So obviously nobody is required to stay. Nobody's chained to a computer, but this program is pretty much designed to run an hour and a half. And if that takes anyone by surprise, my apologies, but that's kind of the length of the program. There's a lot of technical material in the program, and so this program is done by PowerPoint, but it's a different kind of PowerPoint. It's pretty much going to track all of the substantive points. And so there's no need to really take notes during this presentation because the slide deck will be circulated to everybody after the program. And so you'll see a lot of text on the slides. They outline the program, and Wolf will take care of that when we're done. This program is focused on impossibility and commercial frustration. It does not focus on any emergency orders at the state, the county, or local level. That would be a different topic for a different day. And so let's get started. I'm a mediator. I also run a real estate practice. And over the past several weeks, as with many real estate attorneys, I've been getting calls about people having problems with leases. And I see this from both sides. I see this both from the commercial landlord side and the commercial tenant side. And so this program really isn't focused on residential transactions or leases, although the same principles are going to apply. The thrust of this program is on commercial tenancies. Here's the general statement, and this is going to be familiar to everybody who does contract law. A contract in its inception must possess the essentials of having competent parties, a legal object, and a sufficient consideration. Lacking any one of these, no binding obligations result. Hence, a contract which contemplates the doing of a thing which is unlawful at the time of the making thereof is void. What we see here in the cases that we'll talk about this morning is that these impossibility and commercial frustration cases go to these two: legal object and a sufficient consideration. When you end up with either one of those lacking, then the courts void the contract and find the parties discharged. For the same reason, a contract contemplates the doing of a thing at first lawful, but which afterward and during the running of the contract term becomes unlawful, is affected in the same way and ceases to be operative upon the taking effect of a prohibitory law. Not every case involving commercial frustration involves something becoming unlawful, but this fits very comfortably with the situation we're in right now with COVID-19. There can be other commercial frustration situations that don't involve some kind of prohibitory legal order entered by a governmental entity. It's just one subset, being unlawful or other considerations. We'll see that more in detail with the cases. The title of the program is What Happens When Force Majeure is Not Enough. So we will have some discussion in this program about force majeure and its interplay with the law of impossibility and commercial frustration. Force majeure comes from the law French. It literally translates to a superior force. It's defined in Black's Law Dictionary as a contractual provision allocating the risk of performance becomes impossible or impracticable as a result of an event or effect the parties could not have anticipated or controlled. This is the heart of force majeure clauses. It allocates the risk of performance, and it can either provide for a complete discharge or a delay in performance. And we'll talk about this more, but force majeure clauses at their essence provide that either the performance by one of the parties is going to be allowed to be delayed because of delay by some unforeseen event, or it provides that the contract will be discharged. These are key points here at the end. Effects that the parties could not have anticipated or controlled. We see consistently in the cases that if there's lots of statements by California Supreme Court and courts of appeal, that if the parties could have anticipated or controlled, especially anticipated, the event, then there is no application of the doctrine of commercial frustration. Impossibility of performance doctrine. This is the principle that a party may be released from a contract on the ground that uncontrollable circumstances have rendered performance impossible. Commercial frustration is an excuse for a party's non-performance because of some unforeseeable and uncontrollable circumstance. What you'll see as we run through this program today is that there's a lot of overlap in the language between these three principles. And force majeure is not really a principle, it's more of a shorthand way of saying we're going to allocate in advance between the parties the risk of delayed performance or non-performance. So really it becomes more like two principles and a third application, with the force majeure being the application, impossibility and commercial frustration being the principles. We'll talk more about the difference between those two principles in just a moment, between impossibility and commercial frustration, as shown by this slide. A defense of impossibility must arise in the nature of things and not in an inability of the promisor to perform it. So there's case law that says that if you put your own ability to perform out of your control so that you now cannot possibly perform the contract, you're not allowed or entitled to assert the defense of impossibility. So it can't be because you either had ability to perform and made yourself so that you couldn't perform, or it can't even be in your own inability to perform it. It must be an objective test that the contract cannot be performed. And then the defense of impossibility can be asserted. Here's a hypothetical. A contractor signs a contract to perform work on an existing building. The building is subsequently destroyed without fault of either contractor or the property owner. What is the effect on the contract? So there's an enforceable contract written, meeting of the minds, consideration, competent parties, lawful objective. Valid contract, the building is destroyed, neither party's at fault, and the courts are careful to point out that that's the case when they apply these doctrines, that neither party is at fault for causing the impossibility. But what's the effect on the contract? Can the owner require the contractor to perform? Can the contractor claim lost profits because they can't perform? No. The effect on the contract is it is discharged and neither side is obligated to perform. Here's another impossibility example. A contract to manufacture goods in a particular factory where the factory is destroyed. In that case, a contract is discharged because it cannot be done. Literal, actual impossibility. A contract to ship goods on a specific ship, which is lost at sea. Again, discharged. These are old cases. You look at these dates, 1921. Just as an overview, if you go to Witkin and you look at the pocket part there are no recent cases on any of these doctrines. Most of these cases come back out of either Prohibition in the 1920s, or the First World War, or the Second World War, although there are some other cases that don't rely on those, but those are where most of the cases come out of. Here's a contrasting commercial frustration case example. The contrast is between commercial frustration and the doctrine of impossibility. And when I say the doctrine of impossibility, what we're talking about is a defense to enforcement of a contract based on impossibility. It's a contract defense. So here's the case example. And this is illustrating commercial frustration as compared to impossibility. And the impossibility example is the one we just spoke about with a contractor who could not build because the building had been destroyed. That's a classic example of impossibility. This one is Mitchell, and this is from a California case. Mitchell leased a burglar alarm system from FLC, and the alarm equipment worked flawlessly. Now, FLC was not the supplier. The supplier was an unrelated third party, not party to this litigation. So this litigation was just between the lessor and the lessee, with Mitchell being the property owner who had the system installed, and FLC being the lessor, and FLC retained title to the equipment. FLC just leased the equipment to Mitchell while retaining title to it. The equipment worked fine. There was no problem. Following the installation of the system, the United States District Court issued an injunction enjoining any use of the equipment and all other equipment like it because it interfered with secret government radio frequencies. There is no further discussion in the opinion about what those secret government radio frequencies might be. That's left to conjecture and speculation, but the court issued an injunction on that basis. Neither Mitchell nor FLC had any knowledge of this problem when the lease was signed and the equipment was installed, so it blindsided both of them. Mitchell, understandably, sought to rescind the lease because if he did not, then he would be obligated, per the terms of the lease, to continue to make the lease payments even though the equipment worked flawlessly, but it had no use to him. FLC, on the other hand, filed suit for the remaining lease payments because they owned title. They had a perfectly valid system that worked fine. The equipment worked flawlessly, and they had a written contract. Here's another wrinkle. The lease agreement specifically provided that if the equipment is not properly installed, or if it does not operate as represented or warranted by the supplier, or is unsatisfactory for any reason, lessee, which is Mitchell, shall make any claim on account thereof solely against the supplier and shall nevertheless pay the lessor all rent payable under this lease, lessee hereby waiving any claims against the lessor. So the purpose of this clause is immediately apparent. In preparing the lease, the lessor sought to make sure that their claims, that the lessee's claims for non-functioning of the equipment would all be directed against the supplier, and that the lessee would waive all claims for functionality or any other basis if it's unsatisfactory, so that they had a very clear right to enforce payment. On the basis of these facts, who wins? Is this waiver effective? Does Mitchell end up being obligated even though he cannot use the equipment, or not? In this case, judgment actually was entered for Mitchell, the lessee, due to the doctrine of commercial frustration. Neither party was at fault. The lessor had retained title to the equipment, but the entire purpose of the lease, which was for Mitchell to receive a working alarm system, was frustrated due to an unanticipated supervening cause that neither party could foresee. So this is a more recent case, 1978. Doesn't involve prohibition or either the world wars, but it's a perfect example of the principle or doctrine of commercial frustration. So here's a statement of the difference between impossibility and commercial frustration. This case is from 1947, right after World War II. It is the very same Gene Autry that is the cowboy movie star. He has the Autry Museum down in the north end of the LA Basin, which is actually a really great museum to visit, a lot of history in there about his movie and television work. And he, as a younger man, was actually had signed a contract with Republic Studios, Republic Productions, to do a whole series of what they call photoplays. It's kind of a journey back in cultural history. At the time this case came out, they didn't call them movies or films. They called them photoplays. So a play where you take photographs of it. And all through the course of proceeding, they described photoplays. But he had signed a contract to do a series of photoplays or movies over a period of years. Had the studio had an option to extend. The studio exercised the option, and they were in the middle of this extended contractual performance situation when the war broke out, World War II. And Autry signed up. He enlisted, and off he went to war. What happened is, at the end of the war, or towards the end of the war, Gene Autry filed a lawsuit to have the contract declared void. And the basis that he sought was on impossibility. And you would think, well, you know, he's come out of the war, he survived, he actually could do the performances and honor the contract. But the court, this is a California Supreme Court case. This gives a lot of discussion. This is just one snippet of it about impossibility. And here's the court's, Gene Autry is also seeking to apply commercial frustration, but it really is an impossibility case. Although the doctrine of frustration and impossibility are akin, frustration is not a form of impossibility of performance. It more properly relates to the consideration for performance. Under frustration, performance remains possible, but is excused whenever a fortuitous event supervenes to cause a failure of the consideration or a practically total destruction of the expected value of the performance. In layman's English, this fortuitous event, these days we use the word fortuitous to mean something that happens in a good way, like some unexpected good thing happens to somebody. That's not this definition, and if you consult the dictionary, fortuitous actually just means an unexpected event. That's the primary definition. Although in common parlance these days, we think about it as something good. That's not what the court's saying here. They're saying an unexpected event supervenes, which means intervenes, and is so powerful that it takes control of the actual relationship between the parties to cause a failure of consideration, one of the key required contractual elements. So it destroys the consideration, causes a failure of consideration or a practically total destruction of the expected value. This is actually a very cogent statement of the doctrine of impossibility and a comparison of that to commercial frustration. So impossibility, you cannot perform, or it becomes unreasonably difficult or expensive to perform. Frustration, the object of the contract is destroyed, as in the Mitchell case with the burglar alarm. How does force majeure interact with impossibility and commercial frustration? Remember, impossibility is a doctrine, commercial frustration is a doctrine. Force majeure, though a principle, it really, in this presentation and in common usage, refers to those clauses in contracts or in leases that allocate the risk between the parties in advance. Force majeure is typically a boilerplate or additional lease clause. And because they come out of form books, they're often typically not carefully negotiated. The parties, seems like a lot of times, are more focused on the matters at hand, like term length, price, other considerations. It's one of those additional kind of throw-in clauses. These clauses often allocate the risk of loss between the parties in the event that a contract cannot be performed, or if it becomes more difficult or expensive to perform because of unforeseen events. And that's a key. They must be unforeseen. They typically provide for excused delayed performance or non-performance due to such things as strike, riot, civil unrest, labor shortage, war, terrorism, fire, flood, other casualty, acts of God. Just an aside, reading the opinions, what you see is that a fire is not an act of God. That's straight out of California case law. Unless it's caused by lightning, then it can be an act of God. Force majeure clauses are recognized by statute. Civil Code 1511(2). The want of performance of an obligation is excused when it is prevented or delayed by an irresistible superhuman cause. So the want of performance means non-performance. So when an obligation is not performed, then that non-performance is excused when performance is prevented or delayed. Those are the two key items, considerations. Performance is either prevented altogether or it's delayed. It can be either one by an irresistible superhuman cause, which is just one way of describing what we've been talking about, an unforeseen event that it overwhelms the situation, more or less. Now, here's the caveat. Unless the parties have expressly agreed to the contrary. So this whole contractual defense here about saying, well, I'm excused from performance because I couldn't perform because of this unexpected condition or event or situation. That's a valid defense unless the parties have expressly agreed to the contrary. This is right out of the statute. So this validates force majeure clauses where parties in advance can decide between themselves who's going to bear the cost, the expense, loss, injury, or damage from either non-performance or delayed performance. Here's a case example upholding a force majeure type of clause. A city contracted for the construction of street improvements. The contract provided that if federal regulations stopped the improvements, the contractor would accept as full compensation a proportionate payment for work completed and the reasonable value of work on uncompleted items. The work was apparently stopped due to the federal regulations, and the contractor filed suit for declaratory relief. The reason why this is in parentheses here is because the court doesn't come right out and say it, but you can read it between the lines. So what happens here is that the parties recognized upfront at the time they entered into the contract that there were federal regulations that could be asserted or implemented or activated that would stop the work. And in fact, that happened. The Court of Appeal rendered judgment for the city by upholding the contract, which required the contractor to proceed with construction notwithstanding a long delay and increased construction costs. The court's decision turned on the contract's risk allocation as to uncertain future events. So this case validates Civil Code 1511 and the ability of the parties expressly to specify or provide between themselves as to what kinds of risks, loss, injury, cost, damage, the parties will both suffer, or either one of them will suffer, if a contract is either delayed or can't be done at all. There's another case not cited in these materials, a very interesting case, where a contractor contracted to build a house in San Francisco and was to be paid in installment payments. And there were 5 installments to be made, 5 progress payments as construction progressed. The contractor successfully performed 4 of the stages of construction, and the court opinion doesn't say so, apparently was paid. But the issue came up with the 5th. And the contractor, the 5th was some of the millwork and some of the exterior finish work, contract and stucco and millwork and that sort of thing. The contractor finished performance, completed the job at noon on April 17th of 1906. Well, the contract said that payment became due when the contractor finished the work and the architect signed a certificate certifying the completion of the work. So the contractor finished the work at noon on April 17th, and if you don't have this right at top of mind, the Great San Francisco earthquake of 1906 occurred on the morning of April 18th. So less than 24 hours after this contractor had completed the work on this building, all ready to go, the earthquake struck, which caused major damage to the building, and then the fire that followed the earthquake within 24 hours completely demolished the building. The architect had not signed the certificate, unfortunately, by that time. So that became the issue, with the owner, of course, saying, well, payment's not due. The contractor saying, well, you know, I did all the work. And the court spends a lot of time saying, well, it's basically Hornbook law that the contractor isn't entitled to work until the building's completely finished. But the case turned on a force majeure clause, where they allocated between themselves the risk of, it specifically laid it out: fire, earthquake, and other casualties. Then what happens is the contractor is entitled to payment for the amount of work done up through the supervening event, the reasonable value of it. And so it turned into a quantum merit case because of the force majeure clause, and the contractor recovered. So whoever that contractor was 115 years ago or so could really thank their attorney in putting together the force majeure clause that anticipated those kind of events and provided a very workable solution for what happened. I promise it was not a Hornbook stock form kind of force majeure clause. It was specifically crafted for this situation, and it worked. Excuse due to operation of law, Civil Code 1511. Now, the last code section we talked about was 1511 sub 2, which validates and supports force majeure clauses. Civil Code 1511 1 talks about impossibility. When you look at this code section, there's over 200 cases that cite to this code section. So there's a lot of law. And the cases that we're going to talk about on force majeure today, pretty much all of them are included in the annotations to this code section 1511. So that's a key code section, and if you have an impossibility case or a commercial frustration case, you absolutely want to take a look at that code section and the cases supporting it. The want of performance of an obligation is excused when such performance is prevented or delayed by the operation of law. So the want of performance, same as with the impossibility, sub 2. Non-performance is excused when performance is prevented or delayed by operation of law. When you go to the annotations in 1511, there's so many that Westlaw breaks them out into categories, and they're alphabetized. As you scroll down, you come to one that literally says operation of law. And there you see all these cases that address this point here, the statutory point. However, this is enough of an aside that I haven't spent the time to go through and analyze each of those cases because there just would not be time in this program. And so I mention it by way of further resource. You can have a look at it. Otherwise, we would never get through this program in any kind of semblance of the time today that's allotted. So this is a very interesting caveat. And the italics are not in the statute. They've been supplied. What this says is non-performance is excused when it's prevented or delayed by operation of the law, even though there may have been a stipulation that this shall not be an excuse. So what this statute says is, when you have a contract, the parties can stipulate that operation of law shall not be an excuse, but it still is. It still is. Super powerful point. This statute was not addressed in Mathis, which is the case about the street performances. See annotations to 1511 for further discussion. Here's the practical comparison of outcomes proceeding by force majeure clause or by commercial frustration. What this really is, this isn't so much a discussion about the legal doctrines or principles. It's the practical outcomes on whether you proceed by force majeure or commercial frustration. Remember, force majeure are the clauses in the contract that allocate the risk up front. Number one, besides allocating risk of loss due to events preventing contract performance, a force majeure clause typically requires a commercial tenant to still pay the rent, with limited exceptions, such as a delay by a landlord in completing construction of a property. So this is a key point. When you look at the typical force majeure clause, they virtually always say that notwithstanding these acts of God or strike or whatever it is, the tenant's still obligated to pay the rent on time. So if you're a landlord, you absolutely want to proceed by force majeure clause when some supervenient event comes up. If you're a tenant, you absolutely don't want to because they require you to pay the rent. Leases don't contain commercial frustration clauses. They don't say that in the event of commercial frustration that the tenant still has to perform, because the whole nature of commercial frustration is an unforeseen event that destroys the value that was going to be exchanged in the contract. So you just don't see this in case opinions or in contracts. It's provided ex contract. Many of the commercial frustration and impossibility cases expressly note that this is broken off from the previous slide. Leases don't contain commercial frustration clauses. Rather, the doctrine is applied to excuse a party's performance, even though the parties did not agree to application of the doctrine by lease or contract. But many of the commercial frustration and impossibility cases expressly note that the contract between the parties did not expressly provide for certain unforeseen events, clearly inferring that such provisions may have materially affected the court's decision had the parties included them in their contracts. You see this consistently, that when the courts are considering the issue or the defense of commercial frustration, they will consistently say neither of the parties put in their contract that this type of thing was going to be addressed. It's a very clear inference that if the parties had addressed those, as with the 1906 earthquake case, that the court would be considering those or perhaps even basing their decision on those provisions in the contract. With commercial frustration, a tenant is generally excused from payment of rent when the object of the contract has been commercially frustrated. So completely different outcome if the tenant is able to qualify for an application of commercial frustration or persuade the court that it applies as compared to the typical force majeure clause. Here's a case example: impossibility or commercial frustration. A large hotel in Santa Barbara County wanted to provide its guests with golfing and country club privileges at a nearby unaffiliated country club. The hotel signed an agreement with the club whereby the hotel agreed to pay a monthly sum to the club. In exchange, all hotel guests would be provided with golfing and country club privileges during their hotel stays. So that makes sense. You have a very nice hotel. They don't have a country club or golfing privileges or any kind of facility. There's a nearby country club. They can work a deal. The club can agree to provide the hotel guests with golfing privileges while the guests are staying there. In exchange, the hotel just pays a flat rate to this country club. I mean, I'm sure they talked about the number of guests they have and what their projections were and how many people would take them up on it, but they negotiated a flat rate, and that's what they agreed to, written contract. The hotel subsequently burned to the ground, again without fault of either the hotel or the country club. The hotel was not rebuilt, and the land underneath the hotel was sold. So now you've got the situation of this outstanding contract, and the hotel is gone through fault of neither party, and the land's been sold. It wasn't rebuilt. The hotel refused to continue making the payments. Now, if you really took this out to the end of the bell curve, it would be possible, I suppose, to argue, well, the hotel had the power to rebuild and not sell the land and thereby take advantage or perform under the contract. But, you know, if their insurance wasn't good or they were uninsured and they didn't have the money to do it, or if the cost outstripped insurance or whatever the problem was, and those things aren't addressed in the case opinion, the court opinion, they don't go into that kind of detail. So theoretically, the hotel could have maybe taken subscriptions or investments or whatever and raised funds and rebuilt. And so it wasn't absolutely impossible. But this is a good highlight of an illustration of a point about impossibility. It doesn't have to be absolutely impossible to perform. It's either impossible or at unreasonable expense or difficulty. Then you qualify. So here's the next part on this case. The club filed suit. Who wins? It's the hotel. So is the applicable doctrine impossibility or commercial frustration in this case? Was it impossible or was it commercial frustration? It's commercial frustration. That's the way the court characterized it. that the object of the contract was gone, which was there were no guests. And as a practical reality, it wasn't possible to bring guests in from some other location and have them come golf. So the hotel was excused. That's a case out of 1926, not tied either to Prohibition or either of the World Wars. The commercial frustration doctrine as applied to real estate, and just an observation. There are some really great discussions in Witkin about impossibility and commercial frustration. And Witkin wraps those two doctrines together into a single section, not one section, but a single area of the book. And it's a very good overview. It proceeds very logically, very thoroughly, very clearly. It's great in general. Miller and Starr has a great section here that's cited 34-166 that takes commercial frustration and applies it to real estate situations. So if you've got a commercial frustration case, or you think it might be a commercial frustration case, or an impossibility case in a business context, start with Witkin. If it's real estate, it's great to kind of get your feet wet and get the overview by reading through the sections in Witkin, and they're cited at the end of this slide deck. Start with Witkin, get the overview, and then drill down and get very specific as to real estate with the discussions in Miller and Starr. Here's the quote. As a general rule, when premises are leased for a specific purpose, the tenant is obligated to perform the covenants of the lease, though the premises are not suitable or usable for the intended purposes. However, in some cases, when the lease specifies and restricts the use of the premises to a specific purpose, the tenant may be given the right to terminate the lease under the doctrine of commercial frustration if it cannot use the premises for that purpose. Here's an example, illustration. In 1915, a commercial tenant signed a 5-year lease of real estate in Los Angeles County. The lease expressly provided that the tenant would use the property as a general winery and the wholesale retail liquor business, and for nothing else. In January of 1920, an important amendment to the Constitution of the United States became effective. So the lease was signed in 1915. Here's the constitutional amendment in 1920. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited after 1 year. So there's a 1 year warm-up or warning period before prohibition becomes effective on January 16th, 1920. When you look back at the dates on this tenant signed a lease in 1915, 5 full years before prohibition was ratified, and expressly provided for use as a general winery, hotel, retail, liquor business, nothing else. And so it's 1920, it's almost at the end of the lease term, but not quite, that this amendment becomes effective. The tenant offered to pay the rent up through the effective date of the amendment, which seems like a reasonable offer. Landlord refused to accept the rent, instead filed suit for the unpaid rental amounts through the end of the 5-year lease for about 5 or 6 months worth of rent. I have a written contract, you agreed to do it, I'm going to hold you to it. Who wins? The tenant. There's the case citation. And this is, would it have been a different result if the lease was signed in 1919? And the answer is, well, in 1919, that's when the 1 year period started. So then the parties would have foreseen what was coming up, and unquestionably, there would have been no relief for the tenant. The way the court characterized this case is not impossibility, but commercial frustration. Because impossibility, the tenant could still occupy the premises. They could go there every day, they could be there, but and they could pay the rent. The landlord could provide the premises. So it wasn't impossible, but the whole purpose, the whole focus, the thrust of the lease, which was to have a place that could be used for these purposes, was frustrated. So this is a classic commercial frustration case. Here's commercial frustration in a cultural context. This is a difficult case. In 1940, a tenant of Japanese descent or ancestry signed a lease for the entire second floor of a building in a neighborhood of Los Angeles, informally known as Little Tokyo. This is the spelling from the court's opinion. a little window or glimpse into kind of past cultural history. And the court spells it this way several times. It's not a typo. The lease required that the tenant personally occupy the premises, and further required that the premises be used only for a hotel and an office space. On May 3rd, 1942, so we're 2 years into this lease, the commanding officer of the United States Army on the Pacific Coast issued an order whereby all persons of Japanese ancestry were to be excluded from that portion of Los Angeles where the leased premises were located. So he absolutely cannot personally occupy this space because of a supervening governmental order by the commanding officer of the Army. The landlord, undoubtedly trying to mitigate damages, waived any requirement that the tenant personally occupy the leased premises. That seems like a reasonable thing to do, and agreed that the defendant could sublease the premises. So it's clear what the landlord's trying to do here. They're trying to move quickly. It's wartime. There's probably not a whole lot of demand for commercial property in 1940, right after, it's everything's leading up to the Pearl Harbor, not long after. And everything that's going on in Europe, the countries in the world's in a state of upheaval, even though we're not officially in the war at that point. Agreed that the defendant could sublease the premises. The tenant advised the landlord that the tenant was excluded from the portion of Los Angeles where the leased premises were located, and it was impossible for him to comply with the terms of the lease. The landlord filed suit for the amount due under the lease. Who wins? The landlord. The court found that the evacuation order did not make it impossible for the tenant to perform under the lease, nor did the evacuation order discharge the tenant's obligations under the lease. That order required all of persons of Japanese ancestry on the Pacific Coast to be relocated inland. So this was the trial court opinion in favor of the landlord. Complete landlord win. The tenant appealed. The appellate briefs alleged the tenant could only perform as a result of unconscionable hardship, and that the very person who were tenants of the hotel had been evacuated along with the defendant, and that Little Tokyo had become a ghost town overnight. What result on appeal? The Court of Appeal found the record insufficient for determining whether the contract had been commercially frustrated and whether or not the evacuation order, the property could be used as a hotel and office space, given the evacuation order. The Court of Appeal reversed the judgment for the landlord and sent the case back to the trial court for further proceedings to determine whether or not commercial frustration was present. In other words, has the whole purpose of the contract been frustrated? There was a dissenting opinion, or I'm sorry, a concurring opinion, where one of the justices wrote that the evacuation order made these evacuated persons virtual prisoners of the Army, and opined that judgment should be entered for the tenant. So they concurred because it was reversed. They felt the court should have gone further and not remanded for further proceedings, just entered judgment right now for the tenant. Governmental regulation. Under the doctrine of commercial frustration, if some law or regulation is enacted after the lease is executed, and its enactment was unknown and not foreseeable at the time when the lease was executed, the tenant may terminate the lease if the new law or regulation renders performance under the lease impossible. Even though the word impossible is used here, it's not an impossibility defense, it's commercial frustration. And impossibility performance, it is a basis for the commercial frustration, but the thrust of this doctrine is that the purpose of the lease is rendered completely just unusable. Here's a case example on foreseeability. This is a California Supreme Court case, again out of World War II. It's where a tenant leased space at a time when automobiles were soaring because the public anticipated that production would soon be restricted due to the outbreak of World War II. So this is a few years in the pipeline to get to the California Supreme Court. This case actually happened years earlier, or the events underlying the case happened years earlier. This is when it reached the Supreme Court. Though the government restricted new car sales following execution of the lease, the defense of commercial frustration was not available to the tenant, due in part to foreseeable possibility of such restrictions. This soaring nature of car sales basically says, look, this is the court saying to the tenant, you can't see these indicators of unavailability of new cars. In other words, all of the production of Ford and other major companies is being put into Liberator aircraft and war materiel. You can see what's coming down the road, and everyone's buying cars like mad because they think they're not going to be available, and then sign a new lease in the midst of that. And then when the order comes, then say it, and it wasn't an order prohibiting sale of new cars. It was based on rationing. Only persons of certain classifications could buy new cars, so they could still be sold, but to a far smaller group of clientele. The court just says, you're just not going to get there from here. You can't see that writing on the wall. It's foreseeable. And so it ruins the foreseeability issue, and the new car dealership loses. The landlord wins. The doctrine of commercial frustration is an exception to the general rule. It applies only when certain limited conditions are present. Commercial frustration can be relied upon by the tenant to excuse his or her performance of the lease only in cases of extreme hardship. There must be complete or nearly complete impossibility of using the premises for the purpose which they were leased. A mere substantial frustration of purpose is not sufficient. Now, we have not spent a lot of time in this presentation so far, and we will get there, about application of these principles to the current legal environment with respect to COVID-19. But instead, this presentation talks about the principles that are extant in California law. And then, of course, all of our jobs as attorneys and so on is to mediators is to apply these to the current facts of our current situations. But this is out of California Real Estate by Miller and Starr. This is a key point for our COVID-19 situation. A mere substantial frustration is not sufficient. It must be complete or nearly complete impossibility of using the premises. Substantial frustration, so increased difficulty or expense, is not by itself sufficient. We'll see that in a moment. Mere unforeseen difficulty or expense does not constitute impossibility, ordinarily will not excuse performance. However, impossibility may constitute, so this is not commercial frustration as such. These quotes here are out of Witkin's section on impossibility. The previous quote from Miller Starr was talking about commercial frustration, but I've moved back a step to Witkin here. Impossibility may constitute a defense when performance is impracticable or unreasonably difficult or expensive. So these points also apply to frustration, but this is out of Witkin's treatment of impossibility. Now look at these. This one here says, mere difficulty, unforeseen difficulty or expense does not constitute impossibility and will not excuse performance. In the same section, 855, at the very end, Witkin says, however, impossibility may constitute a defense when performance is impracticable or unreasonably difficult or expensive. So question, does it sound like double talk? What's the inference? And what's the difference between these two? And as you look at it, it's this word right here, unreasonably difficult or expensive. So for everybody who's spent any time practicing law, what does that suggest? Here's the question. Is this degree of difficulty or expense, unreasonable, likely to require a factual or a legal determination? So you can just script this. In every case where this gets applied, it's going to be a weighing process. The court's going to be looking at how difficult or expensive, how much more difficult or expensive is it given the governmental order or the unforeseen difficulty? Is it just some, or does it virtually destroy the value of the lease, the premises, the contract? So it's a weighing process, which of course is going to be legal determination. No, it'll be factual. The court might discuss the law, but how much is it? That's what they'll be looking at. Here's a case example as to substantial frustration. A guarantor guaranteed a lease allowing certain premises to be used for the business of a saloon and a cigar store and for no other purpose. However, the lease allowed the tenant to sublease to a bootblack. During the lease term, a Wartime Prohibition Act was passed, which made it illegal to sell intoxicating liquor for beverage purposes. This is different than Prohibition, which was passed and became effective in 1920. There's a different Wartime Prohibition Act, again, made it illegal to sell intoxicating liquor for beverage purposes. After the act was passed, the tenant continued using the lease premises for the other purposes allowed by the lease: cigar store, bootblack, non-intoxicating beverages. The landlord sued the guarantor. So this is a suit by a landlord against a lease guarantor when the lessee had not paid. The landlord sued the guarantor for unpaid amount due under the lease. The guarantor asserted the defense of commercial frustration. Who wins? It's the landlord, because the premises remained partially usable and, as noted by the court in its opinion, were in fact used by the tenant. So what this tenant is trying to do, you can read between the lines easily. They're trying to either get out of the lease early because it's unprofitable, or they're trying to say, I don't have to pay the rent because I can't use the whole premises for what it was agreed to be used for. And the court here in this Grace versus Croninger case, one of the leading cases, just says, no, it just does not work that way. If it's just an increased difficulty or expense, no availability either of impossibility or commercial frustration. Now, this even brings us closer to the COVID-19 situation today. This is the question of contract suspension versus termination. California contract law does provide that an obligation to perform may be suspended under the doctrine of temporary impossibility until performance is possible. Thus, here's a case example. A seller of millions of pounds of barley, big-time barley producer, was excused from making barley shipments during the period of a 2-month embargo, but the seller was obligated to complete its shipment once the embargo was lifted. This is the case citation 1922, and this is well after, this is 3 years after World War I, so this is outside World War I, but there were other conditions that created this temporary embargo. The court in this case specifically found that it has not been shown, I'm sorry, I misspoke. It's 1922, this was with World War I, and the embargo, and it just took this long to get to the court. It has not been shown that there ever was any probability that the embargo would continue for such a length of time as to frustrate the object of defendant's engagements from a business point of view, nor was this governmental regulation of such a character that in and of itself it frustrated the real object of the contracts. The thing that's important to note here is in the facts as given on the previous page, it was a 2-month embargo. So someone, the seller, was delayed from making payments or shipments for 2 months. And when they didn't make timely payment, then the buyer said, oh, you didn't make it, I'm excused, I don't have to buy. Court said, no, there was never any showing that the embargo would continue for so long as to frustrate the object of the contracts to deliver the barley. So in other words, what the court's inferring here is, if at the time when the embargo became effective and the barley seller could not ship, if there was some showing that these embargoes were going to go on for a really long period of time, now we're talking about impossibility or commercial frustration. If you actually can't ship, the purpose probably would be commercial frustration, and be the whole purpose of the contract had been frustrated. But the court's saying there wasn't any showing of that. And here's the court statement. This is not in the case just cited. This is another case, but it's for the same principle. It's the Bergen case. For performance of a contract after a temporary suspension does not impose a substantially greater burden upon such promisor, his duty is suspended only during the period his performance was hindered. He must thereafter perform. So in the barley shipper example, it was only a 2-month suspension. The embargo ended after 2 months, then he's obligated to perform, and the buyer's obligated to accept delivery and pay. It's just temporary. So this is an established principle in California law, that there is such a thing as a temporary impossibility. Here's a case example as to substantial frustration and length of frustration. In 1941, a lessee leased an advertising electrical display consisting of several neon signs and tubing for installation at his drive-in restaurant. So this is easy to see. Someone's got a drive-in restaurant in the 1940s. They want an electrical advertising display of several neon signs and tubing. They want to have increased business, increased traffic at their restaurant. The lessor retained title of the signs and tubing. So if the drive-in restaurant owner couldn't afford to buy, or for whatever reason didn't want to buy these big, expensive electrical neon signs, then he just allowed somebody to lease it to him. So the lessor retained title to signs and tubing. The block lettering on the signs made them visible during the daylight hours. So you can see what this is. It's a big drive-in. They've got these big block lettering on signs, stands, drive-in, whatever you want to have, whatever the name is, outlined or accentuated by neon tubing. So even though the signs are visible during the day, the block lettering on the sign, the purpose of the lease was to illuminate the drive-in at night. And the court does quite a discussion on this, analyzes the language very carefully. It was an electrical advertising display, which is different than just an advertising display. The court really focused on that electrical part. So that's the real nub of this contract, is the electrical display. Then in 1942, a governmental order prohibited the illumination of all outside neon or lighting equipment between the hours of sunset and sunrise. So it's a blackout orders on the Pacific coast. The lessee offered to surrender the lease and allow the lessor to remove the signs. The lessor refused. So the lessee says, hey, I want an electric sign. I'm not getting that much benefit from just the block lettering. Take the signs. I don't want to pay. And the lessor says, no, got a contract, hold you to it. Filed suit. The government order restricting outdoor nighttime lighting lasted 14 months. And the way we know that is by the time the court gets, by the time the case proceeds to the reviewing court's opinion, they can see it's been more than 14 months. And of course, at that point, the lessor that owned the signs and leased them to the drive-in owner saying, hey, this was only 14 months. This was just temporary. The lessor claimed the government orders merely suspended the contract rather than terminating it. Who wins? It's the lessee. On application of the doctrine of commercial frustration, the promisor is discharged from the duty of performing his promise. Such frustration brings the contract to an end forthwith without more and automatically. So in this case, the court said, no, it's not just delay and then you pick it up on the back end and pay at the back end. No, you're discharged automatically and without more if the doctrine, commercial frustration, is applicable. Now, this is an application to real estate of these principles. So there is such a thing, as we've just discussed, as temporary suspension or temporary impossibility. In a lease situation, that leads to this really important question of if you've got a tenant in a property and you have a supervening cause, like a government order that says you can't go to the property because you've got to reside at your place of business if you're a non-essential place of residence, if you're a non-essential business, and all your customers can't come to your place of business if it's a non-essential business, then under all the case law, that is really, unquestionably, undoubtedly, a supervening cause. And it doesn't just cut your business down if you're not a restaurant that can do maybe takeout or something. If you're a nail salon, you're a spa, a day spa. I mean, it's absolute, and it's absolute destruction of the value of the lease. So here, as we've talked about, temporary impossibility, the question comes up, well, is this just a temporary impossibility so that the obligations are suspended instead of discharged? So when you take these temporary impossibility considerations and you overlay them onto a real estate lease, you come up with this key point. Commercial frustration excuses a tenant from performance under the lease agreement and payment of rent by allowing the tenant to terminate the lease, as we have talked about. Commercial frustration does not excuse a tenant from paying rent where the tenant continues to occupy the leased premises. Continued occupancy by a tenant renders that tenant liable for payment of rent, even if the purpose of the lease has become commercially frustrated. Here are the legal authorities that underlie that proposition. In holding a lower court opinion excusing a tenant from paying rent due to commercial frustration, the California Supreme Court held the opinion might be understood to hold. The court's here talking about the appellate opinion or the lower court opinion. The opinion might be understood to hold that the lessee in such a case could continue to hold possession of the premises after the prescribed business became unlawful and escape payment of the rent on the ground of such illegality without surrendering to the lessor. We do not think this is the law, and the opinion must not be so understood. This is an interesting case. You look at the citation here, it's a Cal App citation, so it's an appellate court opinion, But the quote here is from the Supreme Court. So how does the Supreme Court get quoted from an appellate court opinion in not a previous case for precedent, but this very dispute? How does that happen? Because this case, though it's an appellate case, it was submitted to the Supreme Court. The Supreme Court declined to take it on, but what they did do is they sent it back to the appellate court with a little commentary that's appended at the end of the appellate court opinion. And this is the statement that is appended from the Supreme Court. So it gave some commentary on the case without formally taking it on and reviewing it. So Supreme Court authority, even though it comes in a CalOp opinion. The court in Grace versus Croninger reached the same conclusion. A lease is not terminated merely by the enactment of the law declaring such business unlawful, but liability under the lease continues as long as the lessee continues in possession. So here that takes us to the COVID-19 lease analysis. Here's one possible way of doing it, recognizing, and that's a profound point. If you've got a tenant and they're really struggling because they cannot make their absolutely no income at all, and they don't have a reserve of money to pay these lease or these rent payments, they're really struggling, and the landlord is digging in, refuses to give any kind of rent concessions or forbearance. Does that tenant have any rights under impossibility or commercial frustration law to come back to that landlord and say, no, I have a right for forbearance or forgiveness for rent for you because of impossibility? Not under this case, not under the Grace versus Croninger case, not under the industrial development case. This case specifically, clearly, unequivocally says, if the tenant remains in possession, they are liable on the lease. So it really ramps up the stakes. And if the tenant really wants to assert impossibility or commercial frustration, not only do they have to evaluate the considerations we'll talk about in a moment, but they've got to vacate. They got to turn over possession, say, I'm excused, lease is terminated, here's your keys. And if you've got tenants that have got a lot of goodwill or a lot of furniture, fixtures, and equipment or other capital improvements, and all they need is for the economy to be reopened, I mean, that's a completely drastic move. Realistically, not going to happen except in the worst situations. And in that case, it's going to be either, discontinuation of business at this location or bankruptcy or something else. So here's one way to analyze COVID-19 lease situations based on what we've talked about so far today. Under the present shelter-in-place orders and with respect to commercial leases, here's one way to look at it. Was the supervening event, which is the shelter-in-place order, unforeseeable by the parties? Was the supervening event uncontrollable by the parties? Is the landlord's performance rendered impossible? In other words, has the building been destroyed so the landlord can't provide the value from the landlord's side of the premises? And of course, the answers to these questions are self-evident. Is the tenant's performance rendered impossible? In other words, can the tenant not pay the rent? Well, of course not. Are the premises partially usable or fully unusable? So we'll talk about that in a minute. Is tenant's performance only substantially more difficult or expensive because of the governmental orders? Remember, this is not a basis for excuse or for avoiding the lease or for termination. It's only substantially more difficult or expensive. It has to be a complete destruction or nearly complete destruction of the value. Did the parties allocate the risk of COVID-19 or something similar by contract? Force majeure clause is going to be controlling. Most leases, there's a lot of leases that are not going to have this. Is the very purpose of the lease frustrated by the orders? Is the problem temporary or indefinite? If it's temporary, you're not going to qualify for permanent impossibility, and on a lease situation, a temporary situation, you're obligated to perform once the event subsides. In order to apply commercial frustration, it has to be indefinite, of such a term that it's not just going to be a short-term kind of a thing. Is the tenant still occupying the premises? If so, are they willing to vacate? If they're not willing to vacate, as we've just talked about, then they're stuck with the lease. So here's a practical consideration. In every case of application of commercial frustration to tenants, commercial tenants, the following key questions will be answered with the benefit of hindsight, meaning if there's a breakdown in communication and negotiation between landlord and tenant and it comes to blows and you end up in court and you're now putting this up in front of a judge 2 or 3 years down the road, then everyone's going to be looking back at these key questions with the benefit of hindsight, knowing how it all worked out, which we do not have now. Are these shelter-in-place orders a temporary, an indefinite, or a permanent commercial frustration for cases that otherwise qualify? In other words, if you've got a restaurant that has substantially the same income or a significant income and it's just reduced, you're probably going to be back in that case with the bootblack and the saloon. You know, that's the operative law. Those are the leading cases in California on this. But if you've got a nail salon or you've got some other, you know, some other kind of place that's completely closed, it may be completely different. If these orders are indefinite, does their reasonably likely length of enforcement of the orders justify invoking the doctrine of commercial frustration to excuse the tenant from lease obligations or to terminate the lease? This is the $64 question right here, this weighing process. So not only in analyzing these cases, you not only have to look at the way things look right now, but you have to make an evaluation of how's it going to look 2 or 3 or 4 years from now, unless of course it's settled, it's mediated or settled. One size of analysis does not fit all. Situation with banks and pharmacies full operation, that's going to be difficult at best. Restaurants, partial operation ticket only, more purchase, more traction than banks and pharmacies, but absolutely a case-by-case basis, no question. Retail stores, hardware and auto parts are operational. They're going to be in the same situation as banks and pharmacies. Others may be closed, and then of course, everything's changing right now. Maybe clothing stores or sporting goods stores that had been closed are now open. So then the question is, what happens in the future? Is there reinfection in 6 months? But certainly right now, if they're allowed to be open, you know, and then the question is, so they're open, but the clientele are afraid to come because of clothing, because of COVID-19. Is that a valid justification or basis for completely destroying the value of the lease or nearly complete? Again, very, very challenging questions. Movie theaters fully closed for now. Negotiations. Tenants remain liable for rent payments and lease performance as long as they remain in the lease premises. Tenants who want to remain in their premises but need rent relief will need to negotiate workouts with their landlords. The value of the doctrine of commercial frustration in such negotiations will be mainly in connection with discussing the final, possibly drastic action of lease termination and vacating the premises. So here's the negotiation considerations. You can talk about a rent deferral with delayed repayment. So we're seeing all of this. Some landlords are saying, yeah, I'll let you pay no rent for some months and partial rent for some months, and then you're going to repay it amortized over a year, 2, 3, 4, whatever. So delayed repayment, rent deferral, just to help the tenant get through. And of course, the tenants want to be successful. The landlords, unless they have a tenant they don't like, want to see the tenants be successful. It's probably not a really great time to be trying to lease premises for commercial tenants right now. So the landlords have a vested interest in seeing the tenant be successful. If they're a decent tenant, then they like them anyway. Then there's rent deferral with forgiveness absent for further default. Landlords who are in clear title of their property with no liens and no debt service are in a better position to do absolute forgiveness. So this deferral, if you've got a landlord with their own debt service, they may well be far less willing to talk about a straight out forgiveness. And then rent abatement, immediate forgiveness. This one, you know, you see this sometimes in workout situations where maybe the landlord will say, you know what, I will forgive a month or 2 or 3 rent, and then we're going to carry it forward. I'm actually not going to forgive it. I'm going to defer it to the end of the lease. And if you're not in default at the end of the lease, then I forgive it. And then the landlord helps the tenant at this point in time, but also retains that as an incentive for the tenant to remain current on their lease payments through the end of the lease. If not, and there's a lawsuit, then the tenant's not only on the hook for whatever they didn't pay later on down the road, but for this deferred rent as well. So it's to try and help get a little bit of value to the landlord to help the tenants, you know, want to stay current on their lease. If you do these, there can be cancellation of indebtedness income. So you want to talk with your tax advisor, make sure that you're not going to get blindsided with an adverse tax treatment that you're not factoring into your negotiations and proposals. There's some additional considerations, and this is typically going to be for larger tenants, not for smaller tenants. Smaller tenants don't typically get into this kind of sophistication, this kind of complexity with their financing structures. Additional considerations will be whether a forbearance request may trigger a default under a secondary loan. So if the tenant, a larger tenant, maybe has other loans that might be considered to be in default if there's a forbearance request, or they aren't staying current on their rent, and it may be like a deferral to the end of the lease. Is that going to trigger a default? That has to be evaluated if there's secondary loans where that may arise. Whether it's going to trigger a right to terminate an agreement for the tenant not having paid its obligations on time. If there's another related agreement, that has to be evaluated. Consider whether a forbearance request may trigger a right to remove a manager or a general partner from managerial or oversight positions. So if someone's position is dependent on the tenant staying current, and if someone else has a right to remove that person, that has to be evaluated in conjunction with the forbearance request. Or whether there might be personal liability on a personal guarantee. So if you've got a lease with a guarantee and you only negotiate the forbearance or forgiveness on the loan and don't wrap in the guarantee, there's a possibility there for perhaps a blindside or a disappointment. 2 takeaways. Know your deal structure, the affected corporate documents, know your rental agreements. These points have been extracted from a really great article. It's not terribly long, at law.com/corporate counsel, which lists key considerations for commercial landlords and tenants. It's a quick read, very worthwhile if you've got more sophisticated tenants. And here's the URL. It'll come with the slide deck. And if you don't really want to type all that in, just email me, and I'll be happy to copy this URL and send it to you and save you having to type it in. Here's the cases. We've been through most of these, and they'll be at the end of the slide deck. Some we didn't get to, some we don't talk about. And at the end, here is the statutes. These are interesting statutes on impossibility. This is the key one we talked about, 1511. And then the treatises, Witkin and Miller and Starr. And so at that point, I think we have a few minutes available for questions. So Ann, I'll invite you to do whatever we need to do.
Okay. So there are a few questions in the Zoom chat. It moved. Hold on. Randy, do you have questions?
I think I have, we have of course we have compliments, and then here's one question. It's a longer one. I'll see. What if a commercial lease agreement contains a quiet enjoyment clause, essentially contractually promising use of the premises? Is that another argument for non-payment of rent since the lessee cannot use the premises while it is closed to the public? So it looks like they're focused on the use clause.
This is just my take from having spent a lot of time in these impossibility cases and commercial frustration cases. If this comes to blows and parties are represented by counsel and the counsel are negotiating with each other, if opposing counsel is up to speed or becomes up to speed on commercial frustration and impossibility cases, I would expect to see them wrap this quiet enjoyment clause into a use of the premises on an impossibility or a commercial frustration basis, and just say it doesn't give you any greater rights than what you already have under the lease, which is to use the premises. And you either have use or you don't. And if you only get partial use, then you're thrown right back into these commercial frustration cases that we've just been talking about. That's what I would expect if they're doing their job and up to speed.
So are there any more questions anybody wants to type into the chat before we wrap this up?
It looks like another one came in.
Oh, good.
Do you anticipate a shift in decision from the Grace case because so many tenants have sought to defer payment of rent during governmental shelter-in-place orders?
Interesting question. It really asks for kind of my take on this after having spent a fair amount of time, considerable amount of time in these cases. My answer is, and this comes from sort of the position or the perspective of having spent a lot of time looking at these cases, I don't think so. The reason I don't think so is because the law on this goes so far back. I mean, it goes back well over 100 years, and it's very consistent on this commercial frustration case. And it has to be a near total destruction. And so if either the Court of Appeal or the Supreme Court did come in and make a variance on this and reverse course, it would be I mean, they would really be setting a new course all of a sudden in the face of very similar drastic circumstances like the World Wars and Prohibition. Oh my word, those were at least as dramatic as this. And one of the cases comes out of the Spanish flu epidemic in 1918, virtually exactly like this situation we're in right now. So they would really take a major departure. So I don't expect it. Having said that, you know, I've been wrong before, but I don't think so.
Okay, we're getting more questions are coming in, more compliments are coming in as well, because it's got to be tough to do this presentation staring into the camera with no feedback. Let's see, they're really rolling in. So let me see if I can find the.
Okay.
Here's one. Do you think extreme hardship can be defined by individual jurisdiction?
Not sure I understand that. Extreme hardship, individual jurisdiction.
I think that might be focused on the shelter in place variance, you know, variances that will come across for, say, Napa versus further north or
based on what I've seen on this, I think in every situation, extreme hardship is going to be a factually sensitive, extremely factually sensitive determination. So it will have to be determined on a case-by-case basis. And all we can do is look at the cases that have been decided, see what kind of patterns we can detect on what the court has determined as an extreme hardship, and try and make our best projections about how that's going to apply to our individual facts. But the cases that I've seen of individual, we didn't get through all the cases, but there was another tire case, a couple of tire cases out of World War II where people had signed leases to sell new tires and tubes. And the court kind of reigned all over those tenants. They just said, well, you can still do this, you can still do that. You know, it's not, you can't sell tires at all. It's just restricted because of rationing cards. No, tenant is still liable. So it's got to be pretty severe in order to qualify these based on current law. So yeah, I think it will be determined on a case-by-case basis, but I don't see anything other than that. Next one I see from Marta is, do you see in your practice that landlords are willing to negotiate? And the answer is absolutely yes. I mean, what I'm seeing is, and you really have to make an evaluation, a determination of the personality of your landlord, you know, and the ones who are maybe less aggressive, and I do have some of those. Yeah, they're really willing to work, and they like to straight up forgiveness, not even a deferral, just complete rent forgiveness. If they don't have debt service, it's easier. If you've got a landlord with debt service, I have some of those, and you know, they're wanting a repayment, and so it really depends on your landlord. But yeah, I am seeing landlords negotiate. It's really in the landlord's best interest to do that, because if they take a real hard line, and if that tenant is on the edge anyway, a lot of the tenants are feeling like even when the economy opens back up, that it's not going to be like it was before, because people are not going to, they're going to change their spending habits. They're not going to be comfortable coming out of their homes as much. They just think it's really going to be different, right, wrong, or indifferent. That's some of the tenants' mindsets. So if the landlord is really aggressive and the tenant's at all close to not being able to make it work, you know, they just may pony up and give up. And then the landlord is left with an empty space and a claim against a tenant that couldn't even make their business work, you know? So what good is that? So yes, I do see landlords who are willing to negotiate. Let's see, and I've got the questions here, Andy. I can see them. Right.
Okay, I see.
Office building lessor says they are still open for business during stay-at-home orders. Lessor fails to deliver mail to tenants, fires cleaning crew, then announces that the building front staff have coronavirus, as well as one other employee. Tenants told building still open, pay your rent. Okay, that's exactly what we were talking about with the landlord that digs in and coming to blows. So this is not the nice, easy relationship of a very non-aggressive, cooperative landlord, which there are some. This is a much more come to blows kind of situation. So, I mean, the first question for me on that is, and this is going to the end of the analysis, is the tenant willing to vacate? You know, because right now, as far as the application of commercial frustration, which allows you to terminate the lease, if the tenant under the way the law reads right now, if the tenant stays in possession, then they're liable under the lease. So if they're going to negotiate or prevail, negotiate means they stay in the lease, or maybe they vacate and try and get out of a lot of liability. If they're going to negotiate or come to blows and file litigation, if they're going to do that on the basis of these kind of quote unquote breaches from the landlord, then what they're really looking for is a counterclaim against the landlord for breach of contract with some kind of an offset. Otherwise, they're on the hook for the lease, and it's whatever they can persuade the landlord to give them as an offset, or the court if it goes that far. But it's not commercial frustration where they get to absolutely kill the lease. It's on that one. Some cities allow tenants to defer payments if their financials show hardship. And yes, this looks like an observation. This program doesn't talk about emergency orders or any of these applications. So anything that you're looking at with local, state, county, or government orders or specific arrangements have to be superimposed on the top of this. This program does not take any of that into account. Those are all separate. Great, I see a bid for that phone book program coming up next. The phone book, great. Yeah, that'll be a good one. Thank you for that. Great. Appreciate the comment. Unlike commercial frustration, do you have to have force majeure clause written in a lease to be able to argue it? This is worth talking about for a minute. No, you don't have to have commercial frustration or you don't have to have force majeure in a clause to argue it. No, you absolutely don't. In fact, if you go look, I mean, honestly, if we took a vote, what is the most common real estate contract entered into in the state of California right now? The single most common real estate contract entered into, what is it? So it's the CAR. It's the California Association of Real Estate Purchase Agreement for Single Family Homes. I mean, that's going to outstrip any other real estate sale contract by orders of magnitude. And when you go and look at that, look hard for the force majeure clause. Look hard for it. So why does the most used contract in the state of California, and I can't cite the authority for that, but we all just know it, practically speaking. Why does it not have a force majeure clause? I mean, that would be an interesting discussion as well. I have some thoughts on that, but another topic for another day. But you don't have to have the force majeure clause. All the force majeure clause, it's like liquidated damages. You allocate upfront the risk of delayed performance or non-performance. If there is no force majeure clause, these statutes, 1511 says, yeah, these impossibility excuses are right there unless the parties expressly provide otherwise in their contract. You don't do that. You can argue them all day long. That's my take on that one.
It looks like it looks like there are a few other comments and things, but it is close to 10:30, and I thought we would wrap this up formally. So I wanted to thank Bob for an amazing presentation, and we'll get back to you about the phone book reading very soon. But we hope you'll do another awesome presentation soon too. So thank you very much. I also want to remind everyone, hold on one sec.